Commonwealth Court is a court where it typically involves matters of state, city, or county or a party. We have the only Commonwealth court like a Commonwealth court in the country. Our Superior Court is a court that handles appeals from the Court of Common Pleas. It is actually one of the busiest courts in the country. It handles over 8,000 matters a year. And our Pennsylvania Supreme Court, just as another little tidbit, is the oldest Supreme Court in the country. And below those courts are the Court of Common Pleas, and then the Municipal Court, which is in Philadelphia, and magisterial district courts, which are in most other counties in the state. Philadelphia is unique in that it has municipal courts. The magisterial district courts are where many landlord-tenant matters can be found. The magisterial district judges are up for election every 6 years. What's also interesting about magisterial district judges is that they don't have to be a lawyer. They have to be somebody who is 21, been a resident of Pennsylvania or in that location for a year, and has to have passed a course and a test. And so, again, you enter with a landlord-tenant matter in a magisterial district court or a municipal court, and as Paul will explain the process, but if there's a result and you're not happy with it, you would appeal that to a Court of Common Pleas. Go ahead, Chelsea. Okay, I will now pass this over to Paul. Thanks.
Thanks, Deborah. So as tenants, there are some protected rights, whether or not you are in a private landlord-tenant relationship, or if you are part of public housing, whether you receive a voucher, such as they're subsidizing your rent, or if you lived in what some know as Section 8 housing, where the housing authority owns the entire property. But blatantly, and actually it's a question on this primary's ballot, has to do with discrimination. And in this case, you cannot be discriminated when you're searching for housing or when you are a tenant. So a landlord, although a lot of them won't blatantly say it, it does happen though, cannot discriminate you on the basis of race, sex, familial status, religion, your national origin, your gender identity, or your sexual orientation, just to name a few. Landlords that blatantly say it are open themselves up to serious issues with the state and potentially with civil litigation. And you don't always have to go to court as a result of this. It's not like, oh, they denied me because of my race, I'm going to sue them. Both the Department of Housing and Urban Development, which you may hear me refer to as HUD, but specifically in Pennsylvania, which is the Pennsylvania Human Relations Commission, will investigate these situations. You can also go to your department's County of Human Rights if your county has those, but locally in central Pennsylvania and Pennsylvania in general, the Human Relations Commission, they accept complaints. They just ask for some evidence of what happened, and they will go after if there has been a serious discrimination. So sometimes the discrimination may not be blatant. So the examples of them, as is on the screen, the landlord may say that once they've met you, once they see what or where you come from or who you are, they may now say the rent is higher than it's been advertised. And you may feel that's specific because, I have young children, or because I'm my sexual orientation, whatever it might be. It could also be that the landlord does not allow you to use all of the home facilities, such as because of your race. It could also be that there's an advertisement that says a property is only available to people without children. Now, there are only very, very few circumstances when somebody can do that. It's called the Mother Hubbard Clause, but it doesn't happen often in Pennsylvania. But very generally, unless the person lives there and they have 3 other rooms, that's the only time they can, quote unquote, discriminate in that regard. All other times, though, the examples that you've seen are examples of discrimination that are illegal in Pennsylvania. So as a tenant, you have rights. Not just me saying that because I'm a tenant's attorney, but that the law does protect tenants and Pennsylvanians in general. So to start, there are very specific things a landlord cannot do to a tenant. So the first thing is that they cannot take or sell a tenant's property if they do not pay rent. There is a very specific procedure that has to be followed to determine if property was abandoned by a tenant after they have been evicted. And if they do not seek to recover it, then it could be deemed abandoned and a landlord could look into trying to sell off that property to try to recover any of their damages. A landlord cannot shut off utilities such as heat in the winter or electricity, water. They also can't lock out the tenant. Those are what are known as self-help evictions, which are absolutely illegal in Pennsylvania. The courts will generally issue an injunction to force the landlord to return the property back to the status quo. And the landlord could be subject to penalties as well, such as attorney fees or any lost damages, such if you had to live in a motel for some time, or because you couldn't use the stove, you had to go and buy McDonald's for every meal, which I don't encourage that. But these damages could be the landlord has to pay back because they took you away from your normal behaviors. They can't harass a tenant. And really what's harassment is a reasonable person. So if I feel I'm being harassed, would Chelsea or would Deborah or Michelle believe the same thing? And that's really what it comes down to in court. But if they're blasting loud music, if they're, prohibiting you from being able to park in your property, if they're yelling at you or threatening you, that's harassment. They can't enter your property or allow others without giving notice. And your lease agreement will very blatantly say when they're allowed in. Now, if it's an emergency, we smell gas, there's water leaking, there's a electrical or there's an absolute emergency like a fire, landlords are not going to be really bound by this. But if it's, hey, you haven't paid your rent, I'm going to force my way into, because I want to change out an air filter, but they're really doing it to keep an eye on what's going on down there, that could be considered improper behavior. If you have an assistance animal, whether it is for a disability or an emotional support animal, those are federally protected animals. They are considered a medical device. So even though they may be a dog, a cat, whatever, the landlord cannot prohibit you having that animal, and they cannot require extra money for that. Now, if you want to have cats, and that's all fine and dandy, but if you follow the law and you are given a medical prescription for a service animal, whether it's emotional or for a physical disability, the landlord cannot say you have to put a down deposit or add to your rent each month because it is a federally protected right. But I have a dog and 2 cats. When I was a renter, I had to pay like $25 or $50 extra each month for what is considered the potential damage that could come after I had left if I were not a good tenant. And last, another right is that they cannot cancel a lease just because they've sold the property to a new landlord. If that happens, you are considered a holdover tenant. The new landlord is bound by the terms of your lease agreement with your prior landlord, and they are contractually bound to it as well. They have the right to ask you to enter into a new agreement, and that's up to you if you do. But if you don't, they are stuck with what you did to the last landlord. And so they can't just say, sorry, see you later. That is protected, so you don't have to worry about your landlord selling the property. Now, so I don't feel like I'm being biased towards just for the tenants, even though that's truly about 95, well, let's be honest, about 100% of what I do is for tenants in my work. But when I teach at my law school at Widener, I do teach on landlords as well. So I wanted to be fair tonight. But a landlord ultimately gets to set the rules about how the property and any common areas, if the property has that, are to be used. If it's done correctly, it's going to be included in a lease agreement, or it could be included in an addendum to the lease, and it can be updated every year. Now, if it's a mobile home park, they can put community rules that are posted, and the idea is that it's conspicuous, everyone knows about it, and everyone's going to be following those rules. But the landlord can't just surprise go, well, today now you can't have any pets. These have to be common, and it has to be agreed to if it's an addendum to the lease. But the landlord at the end of the day gets to set who's going to be responsible for when can you have louder noise, right? What's considered quiet hour? If there's a laundry room, are there specific rules about leaving the wet laundry there or pulling the laundry out and, so that you can get in, which reminds me of college days. If you left it for 5 minutes, they pulled it out and your wet laundry sat on the washing machine. The landlord is permitted to have keys to your property. If you change the locks, you must give your landlord a copy of the key, but by doing it does not just automatically mean that they can come in whenever they want. They still would have to either give notice or whatever the arrangement is in the lease agreement to do so. A landlord does have the right to evict a tenant if they are not paying their rent, if they don't pay on time, and that's consistently not on time, or if they breach the lease or break the arrangements in the lease. There are different timelines that are required and notices that have to be given. The ultimate thing for landlords is that if a tenant breaches the lease and if they cure it, so let's say they have somebody living with them, the boyfriend or girlfriend moves in, you say you've broken the lease because this person moved in. Technically, if that person moves out, it's no longer a breach. Yes, they broke the rules, but they've cured it. So now they're back to being on good grounds with you. You can't self-help. So like we were saying, a landlord can't just turn off the water. I had a landlord remove my client's front door. That was a self-help eviction. It was also 40 degrees outside, but you have to go through the court system. It may seem in some cases a a tenant may be very savvy. They say they know the law. They may have spoken to an attorney like me, but we're not advising tenants to railroad landlords. We just make sure everyone's aware of their rights. But a landlord has to go through the eviction process to formally remove a person from the property. Landlords can also require security deposits, highly recommended. The security deposit should be no more realistically than at least 2 months' rent. Anything higher than that is actually considered improper under the Landlord Tenant Act, at least everywhere, respectively outside of Philadelphia. Philly kind of creates their own rules, and that's not a slight to Philly, but they're so large, the courts allow them to have their own separate rules. But with the security deposit, the idea is it's meant to be used for any damages that are not wear and tear. So if a tenant's lived there for 10 years and the carpet's dirty, tenants they should have cleaned it. But if the carpet's ruined in a high traffic area, if that carpet only had a lifetime of 7 years, you can't go after your tenant for that. But if they punched a hole through the wall, they didn't fix it, you're using that security deposit to fix the damages there. And again, last thing is the landlord, you're not responsible for your tenant's personal belongings. Now, if you know there's illegal items there, you should be telling your tenants to get rid of them or going through the proper channels. But, if they have a Van Gogh in their property, okay, it's there. They get broken into. As long as you're not the one who broke in to steal the Van Gogh, then realistically, it's on the tenant, and hopefully they have renter's insurance to cover their losses at that point. So a good tenant is going to have a great relationship with their landlord. And we always hope to see that. It doesn't always happen. And unfortunately, it does break down as well. But some things, if you're a tenant, some of what we'll call your responsibilities. Pay the rent, pay it on time. Now, we know COVID for the last, 13 months, 14 months now have really thrown things out. And we'll talk at the end about how the government's responded to that. But if you can't pay your rent, a lot of landlords will say there's a grace period, which is like 3 to 5 days. If you know you're going to be late, the best thing you can do is tell your landlord, look, I fell short or I was sick for a week. I couldn't get overtime. I'm working really hard. I'll have it in a couple days. And if the landlord says that's fine, great, perfect. Now, as an attorney, I have to suggest get it in writing, put it in a text or an email, just in case someone comes back and says, no, you never told me. But, when it comes to prioritizing things, rent, just like our mortgages, should always be the first thing you try to go for. And, if you're going paycheck to paycheck, or if you're really struggling with your funds, I know it's easy for me to say, but you should really make your rent your number one priority, and then, kind of reprioritize after those. Follow the lease. When you enter a property, make sure you ask your landlord for a copy of your lease. I have so many clients who tell me, I don't know where mine is, or I never got a copy. And I cringe because it's how did you know what to do, except for what we expect to be the basics. But by knowing the lease and having a copy, obey those terms. If it says you're responsible for the utilities, pay them. If it says you give the landlord X dollars each month to go towards your utilities, pay your landlord that each month. But make sure you're following those rules. And if you're not sure of a rule, talk to an attorney or talk to your landlord. yeah, like we said, make sure you get a signed copy. Communicate with your landlord for repairs. Your landlord's going to make it very blatantly. If it's something as silly as your light bulb burnt out, you're probably going to be responsible to do that one yourself. You may have a landlord that says, nope, that's our responsibility. You have to tell us. They'll tell you how to communicate with maintenance. They'll tell you what to do if it's an emergency, like if you lose air conditioning and it's 98 degrees outside, which happened to me in law school. Or if it's the middle of winter and you've just lost your heat and it is very quickly falling in temperature, your landlord's going to tell you who to communicate with. But if it's, but you need to make sure what's your responsibility and what's the landlord. The worst thing you can do is not tell them about something and then that damage spirals and it gets way out of control. And unfortunately, then they're going to come after you and say, if you had told us, we could have fixed this. Whether it's a small leak, that small leak becomes catastrophic at that point, where something bursts. You saw a little crack in the pipe. You should really reach out to your landlord or maintenance, whatever the responsible party is, and tell them that so that it does not become bigger. If you think, hey, I'm just nitpicking my landlord, I'm confident your landlord will probably tell you, hey, that's not my job. You should handle these things. But the best thing is just be more careful than sorry. Let your landlord know they're going to take care of it. And if they say it's not my problem, it's your problem, okay, fix it. Now, if it's something like they say, hey, the furnace is blown out and it's their responsibility and they say fix it, that's when you're probably calling an attorney like me to look into it. But at the end of the day, you should be returning your property that you're renting to the exact same way it was when you moved in. Now, minus reasonable wear and tear. So again, the carpet in a high traffic area may be a little discolored, but you're probably gonna have to steam the carpet, and that's almost in every lease. If you painted, they're probably gonna say you have to paint your walls back to what it was beforehand. But as long as you're not completely becoming a new interior designer inside and your landlord says that's okay, you need to return it to how it was when you got there, because any damages you caused or anything the landlord has to do to return it to what it was when you moved in will be taken away from your security deposit. And if it's more than your security deposit, the landlord has the right to come after you for those damages that they need to repay the costs. So for the landlords, the main duty is to keep that property in good condition. And the best credence I can give you guys is, would you live in this place? So if your landlord, or excuse me, if your tenant calls you and says, look, I've got bugs in the unit, I've got cockroaches there. If you wouldn't live with cockroaches, go do something about it. If you would, don't tell me, but ideally, you should be keeping this place up what you would just kind of basic common sense. And it's sad that I have to use that term, but it's true. So make sure there's drinkable water, what we call potable water in the kitchen and the bathrooms. Can they shower with this? Or if I put a match near it, is my water going to turn on fire? Make sure there's hot water, that there's heat during the cold months, that there's, now air conditioning is not required, by the way, that's a privilege, it's not a requirement. But if your property has air conditioning and you said it's part of the lease, got to make sure it's working. If a landlord, if your tenant brings you and says, I need something fixed, try to get to it in a reasonable time. If your client's saying, look, my bathroom has a vanity with 5 light bulbs, 1 burned out, I need it fixed in an hour, okay, you don't probably have to stick to that hour. But if it's, my hot water heater just blew out and it's freezing outside and I got to get the kids ready for school, probably need to act a little quicker on those. Now, you're not responsible for anything your tenant does or the damage that your tenant may cause. But if it's something that's just reasonable wear and tear, it's just that something just got tired or wore out or broke down, it's because things mechanical will do that. That's going to be usually your responsibility unless you've directed that the tenant is responsible for everything in the property. It's rare, but if you write that up and the tenant contracts and agrees to it, that is legal in Pennsylvania. But make sure sewage that it's working, smoke alarms are working. Just press the button every, 6 months? Every time we go to spring or fall forward, you should be having the smoke detectors checked or put a new battery in if it's not a hard line. Paint, as long as it's not lead paint, technically it should not be chipping or peeling. If it's lead paint, that's really bad. And there's actually a whole different signature that has to be signed in a lease that says, I do not have lead paint, because you don't want your tenants, or more importantly, their children, chewing on the wall or doing something that gets them very ill. So we'll go to the next slide. A couple more things is, so like we just said, make sure if you do have lead paint or pipes in the property, the tenant has to know, and there, like I said, there is a separate paper that's signed that says either there's no lead on the property or there is lead. Older properties still have lead pipes, may still have lead paint. A lot of more modern, I think it's in the last 20, 25 years, you're really not seeing that as much, but definitely older buildings that's been renovated, but they may not have renovated the pipes. There may be some lead in there at that point, but the tenant must be notified of that. If the tenant pays the utilities separate from the rent, there has to be separate meters to the property. So if you share a duplex, you are only responsible for the electricity in your duplex. If the landlord can't separate out the two properties, the landlord must pay the rent themselves. If the tenant finds out, or if by accident, and it sometimes happens, my house is wired terribly. I find my meter goes to something at a completely separate side of my house. But if there's what's called a foreign load, if there is electricity coming from a different side that is not part of the tenant's apartment or what they're renting, then the landlord is fully responsible for the bill until the electric company can either separate it out or figure out what's going on. And it can be as silly as there's a shed on the property that the client or the tenant has no access to. And because of that, they're paying for that light bulb, maybe $1 or $2, but the utility companies will immediately stop the bill, give it to the landlord until it can be worked out, or they can split off that meter to something else. Also, if the landlord is notified by the tenant the smoke alarm is broken, a landlord has 72 hours to replace that. So, I mean, obviously safety first. So make sure those are done. So I've spoken a lot about leases. I've used the word contract. At the end of the day, a lease is the agreement between the landlord and the tenant that states that the tenant can occupy and use the property in exchange for something in return. Now, usually it's money. Sometimes it can be an exchange of like labor. So, hey, if you work for me, you can live in this property, or if you're employed by me, you can live in this property. That's okay as well. A lease can be oral or it can be written. If it is an oral lease, it is technically what's called a month-to-month lease. If it's going to be for longer than 3 years, though, the lease must be in writing. It is what's called the Statute of Frauds. It's a boring thing that we learn in law school, but anything greater than 3 years, it must be in writing. If you've lived there for 4 years and you say, oh, I've always had an oral lease, technically there's no lease at that point, and then attorneys start to go crazy amongst themselves. But you can orally agree to a lease. Hey, I'll give you $500 a month to live here. Landlord says, okay. It can be as easy as that. As long as you pay them every month, ideally you have a tenancy. But there's a lot of unanswered questions as to what's my responsibility, what's my landlord's responsibility. Things must be in plain language. There can't be very fine print, or it can't be like in an outline or a border around the page. And it's got to be very clear to these things. If there's a question or it's ambiguous, it falls on the landlord. So there are some important things the lease should contain. It should contain the lease term, meaning on what date is the tenant allowed to move in, and at what is the term of their lease. So there's a couple different terms. One is a month-to-month lease, which means every 30 days, it is a new lease technically. Still under the same written lease, but a month-to-month lease means that either the landlord or the tenant can break the lease with no penalty as long as they give 30-day notice to the other. Now, that's dangerous for tenants that if you live there for 5 years and you have a month-to-month, landlord could say, look, I want to go a separate way. They could not, maybe they hate my tie, right? They don't have to tell me that. They can just say, I'm separating it. If the landlord says, I don't like you because you just had a child, there's that discrimination we spoke about earlier. But in a month-to-month lease, the non-renewable lease, there is legally no defense to it. And unfortunately, that's going to happen. You can also have a term lease, such as like every 6 months, 3 months, a year to year. Anything more than 3 years, again, you have to have it in writing. But those leases are important because depending on the length of the term depends on how much notice a landlord has to give before they can break the lease or non-renew it. Or if they can do that, without there being a breach of the lease. For a year or more, actually, I'm sorry, anything more than a month to month, the only way you can be evicted is for the non-payment of rent or a breach of your lease. If it's a month to month, again, it can just be we're non-renewing it. But if I have a 1-year lease that's renewable on August 1st, and today my landlord says, I want you out of here, he can't until August 1st, but on July 1st, it's going to give me my 30-day notice to leave. But if he says, well, you had 20 people living there for a week, yeah, I just broke the lease, there's the way they get me out. Other important things are repairs, who has to make the repairs, smoke alarms, who's responsible for checking them, who's allowed to stay as a visitor and what extended amount of time. You cannot be denied having any visitors. That's what we call the breach of quiet enjoyment. You're allowed to have visitors over, but they can say what time is a visitor not allowed to be there, how many days until they're considered a tenant. So it can be like no more than 2 nights a week, something like that. The lease should contain, if you're a landlord, you should probably put something saying, I just got to give you 24-hour notice, whether it's I'm changing the air filters in the heat, the air unit, or something along those lines, or I'm coming in to put ant traps down just because it's the spring and they show up. Landlord should have information about that in there. Who pays for the utilities? If there's any late charges, if you're late, on what day and how much that late fee is. It's also going to have things like who's responsible for plowing the snow when it gets when we get the white stuff out there, or if you have a property, who's responsible for cutting the grass, weeds, bushes, things like that. Now, an important thing to keep in mind is that in some leases, there may be what's called a waiver of your notice to quit. It's going to be blatant in there. It can't just be snuck in with the fine language. But if there is a waiver of your notice to quit, the statutory, or what the law says, the amount of time that must be given for you to cure before they go to the magisterial court, if you've signed an agreement that waives the notice to quit, your landlord tomorrow could not even tell you, hey, I'm having you leave. They could just file. Now, it doesn't do any good because maybe you would have left already, and now the landlord just threw some money to court that they could have saved. But you need to be very careful. It should be bolded. It's not required. But if you waive the notice to quit and you breach it, whether for non-payment of rent past your grace period, or you break the lease in any term, they can immediately take it to the magistrate. And a magistrate judge should hear your case in about 5 to 10 days. I think it's 5 to 7, depending on the area. So you should be very cautious if it's in there, because the default is 10 days for the non-payment of rent, and 20 days for a breach of the lease, 30 if it's a colder month. So we can do things outside of court, right? I don't have to go to court every day. I'm a trial lawyer by nature, but when I can resolve it by making a phone call or working things out, that's what we want. So if there's a problem, the tenant should notify the landlord. And I strongly encourage everybody, landlords and tenants, do it in writing, whether it's a text message, an email, Facebook Messenger I have seen, but do it in writing. For tenants, if you tell your landlord, hey, I don't have running water, and a reasonable amount of time passes and they haven't done something about it, the tenant can technically take actions into their own hands. And we'll talk about that a little bit later. But if you say, look, I went over, I told them, and landlord says, I don't recall you ever telling me these things, it's a he said, she said, and in my experience, a court will give a little more weight to the landlord than the tenant. So we encourage you to put that in writing.
And Paul, just as a note, even though it's in writing, if you actually write it on a piece of paper and give it to the landlord, you should take a picture of it, right? Or make a copy of it, because then it's, again, a he said, she said, and the landlord could rip it up. Sorry. And
excellent point, and I'm glad you caught that. I'm so used to everything being digital right now because of COVID. But yeah, if you do anything, if it's like I just scribbled it on on an envelope, I got the mail, I just stuck it to my landlord's door, take a picture of it, because judges love when we have proof of it. Security deposits. Landlords, you have 30 days to return it. If there are 0 damages, everything was given to you back perfect. It looks as immaculate as it was when you gave it to them, or the damages that were there when you gave it to your tenant are the same damages when you get it back. But you have 30 days to return it to the tenant. Any money that's removed from the security deposit must be itemized, and you must notify the tenant that when you return the check, if you If there's more damages than the security deposit, you're sending that itemized deductions to the tenant. If the tenant doesn't receive something in 30 days, and there's a grace period because the post office is slow right now, then if they receive nothing, they don't get a check, they don't get a deduction or an itemized deductions, the landlord can be responsible to pay double the security deposit, and the law can require that, and it's to ensure that people are not just holding money for any reason. Now, you need to be careful too whether or not what money you gave was your security deposit or last month's rent. And a lot of leases will say as well, your security deposit cannot go towards your last month, or it cannot be used to pay any outdue rent that you may owe. But if you agree to that afterwards, that's between you and the landlord in writing. But you need to be careful, are you paying your security deposit because it's sitting? If you're going to be somewhere longer than 3 years, it has to be, I'm sorry, actually in 2 years, it has to be in an escrow account. Don't expect you're getting a ton of money. You'll get like 10 cents if you live there for 2 years. So it's not a lot of escrow right now, but they have to give you that money, and they have to tell you every 12 months how much of money your escrow has appreciated in the banks. But I promise you're not investing, but because of your security deposit. If you have damages, make sure you're taking pictures of it, whether you're moving out or you're moving in, and make sure it's being documented, and you're making sure your landlord is aware.
What I've actually told people is when they move into the apartment to take a picture of everything. You know, the sinks, the toilets, the floors, the chimneys, every little crack, chip, take a picture and save it. So you have, because your phone now dates the pictures, which is also really important.
And depending on your landlord, some landlords will do a walkthrough inspection with you where you can go through. Now, I still, like Deborah said, please do take the pictures, keep those for your records, and then save them somewhere, because if you get a new phone, maybe your pictures don't go with you. But if the landlord, when you move in, you could say, hey, could we walk around and just make sure? So for example, when I moved into an apartment in law school, it was one I call it the smoker windows. It had the leak between the two, and it looked like just moisture got between them. I had my landlord note that. And when we went to leave, they said that was my fault that I didn't notify them. I said, time out, I actually have the walkthrough paper and you noted it on there. So then I was not responsible. So most landlords are willing to do it. They'll walk through. If it's like, hey, look, the closet door doesn't stay on the railing. It may seem petty, document it, because then your landlord's not coming to you saying, hey, I needed a $15 bolt because you damaged it. At least you have some proof. You can dial 311 if you and file a complaint with the Department of Permits, Licenses, and Inspections. That may be Philly specific. I'm not sure. I'm seeing nodding head, so that might be a Philadelphia specific.
I think it is. Sorry. Yeah.
Yeah. So, but the important thing is if there are major damages, anything that has to be going towards your health or your safety, if it's my roof is sagging or there is raw sewage coming out of my pipes, you can call your local housing code inspector or health inspector, and they will come out. If it's so bad they have to condemn the property, the landlord has to put you in a proper home. But if it can be repaired quickly, that's the idea. But usually they're going to give the landlord reasonable time to fix it. They're not just slapping the landlord with a penalty right away, unless there's proof like, hey, you were told 20, 30 days ago about this. This is a problem. As a tenant, if you have to make repairs and the landlord either says, I'm not doing it, and it's their responsibility, or they are ignoring the request, you have a couple different options, including what's called repair and deduct. Landlords hate that. What's going to happen? They're still going to take you to court probably, and they're going to say they only paid me $800 and the rent's $900. You need to have a receipt and the notice you gave to the landlord that says, look, I tried to, they didn't do the work. Landlord may say, look, I could have done that work for $200. You had to pay some guy $800. You just took my rent out. The idea is if you can show proof that you gave them notice, you gave them reasonable notice of the repair and they didn't do it, you can have somebody properly do the work for you. If you have a cousin that just does handiwork on the side, I don't encourage it. Get somebody who's licensed, bonded, and insured to do the work. And ideally, it's whatever money you just put into it, as long as you gave your landlord notice of the damage and they have not, again, within reasonable time, you're going to deduct that from the rent. And if you go to court and you can show the judge, here's my notice, here's the work, here's the receipt, I was legally permitted to do it. It's going to depend on the judge, but they normally will give weight to the tenant if you can show that you did give the landlord time and they believe it was reasonable too. So as we stated, an eviction itself is the legal term for removing the tenant from the property. And it can be because the lease has ended, what we call a non-renewal. The tenant has violated or breached conditions of the lease, or they fail to pay their rent. If the landlord files for eviction, the tenant must receive a copy of the complaint. If they don't, and it went to court without them being told, it's automatically remanded back, and the court would kick out whatever happened and give you the chance to hear your case, because you have the legal right as a tenant to explain yourself or to go to court. Now, if you get notice and you just choose not to go to court, whatever happens at court, it's probably not going to be in your favor, but it's really hard for you to then say, hey, I shouldn't be kicked out when you were given your chance to go before a judge. You have the right as a tenant to counterclaim, meaning you can you can sue your landlord under the same action as long as it's within 5 days of the hearing. So if, excuse me, if your landlord's saying you haven't paid rent for 2 months and you countersue because you've got mold in your unit and you had to pay somebody and now it's more than what your rent was, you can technically countersue, and then the judge is hearing 2 cases at the exact same time. Now, you can't self-help evict if you're a landlord. So again, don't turn off utilities, don't change the locks. That's a big one. We've been seeing with what we call boarding houses now, the ones with the electronic locks like you might get at a hotel, they can't change those. Can't remove the tenant's property out until possession has been given by a court. Don't take off their front doors, their windows, things like that. Those are all really bad ideas. So let's talk about what happens when you go to court. So this is the beautiful photo of Philadelphia. Is that actually your guys' courthouse?
Yeah, at City Hall.
Okay, City Hall. So a civil suit is between 2 people. The plaintiff is the individual bringing the lawsuit, and the defendant, even though it always has that negative connotation we think from criminal, but the defendant is the responding party. In a civil court, you're equal, all right? The plaintiff is bringing the action, but no one is sort of looked at higher than the other. In a landlord-tenant case, the landlord is the plaintiff and the tenant is the defendant. The point of a civil suit is to determine whether the defendant is liable for any injury or any harm, including if there's any money that is owed. The standard of proof is what's called a preponderance of the evidence, which just means more likely than not, we just barely tip the scales in favor of the plaintiff. And we always say, think like 50% plus 0.1, if you want to think of it that way. Just has to be a little bit more likely for the plaintiff. It's not like in criminal court, what we call beyond a reasonable doubt, which means there's no reasonable way this could have happened, or there's any doubt reasonably it could have happened another way. So it's a very low standard. It's actually the lowest standard in the courts. The most important thing, though, to know is under the state constitution, there is no automatic right to an attorney as a responding party in a civil suit. Now, there are programs. I know Philadelphia has created a eviction program, and I'll let Deborah speak to that. But in a standard case, if you're being evicted from your home, there is no automatic right to an attorney, similar to if you are a defendant and you're arrested and you're eligible for the public defender. Now, there are programs like mine, Legal Aid, that are all over the state and in other states as well, that do this work at no cost to the client to represent in civil suits, especially when someone is at risk of losing their property, their home, stuff like that. But don't expect going to court and just saying, hey, I'm here for my attorney. It doesn't exist unless you look for it in programs like mine.
There are some courts do have, I would like to say they're called tenant advocates, who sometimes, and in COVID, you don't see it that much now, who actually sit in the court and sort of monitor the courtrooms and have some knowledge of basics, but it's not frequent. And right now in COVID, it's not happening, unfortunately.
So how a case gets to court, the landlord and or the tenant sees that there's a violation in the lease or that the law is being violated. A complaint is filed in the magisterial district court, but it has to be filed where the property is located. There are websites that will actually help you, or if you call a magistrate and just say, here's my address, am I in your district? If they say no, they might say you're in this district and they have to file there. Now, depending on the court, there may be interviewers to assist in completing the forms, or there might be like a help center or like a help station. Not every court has that though. So, you know, you may be required to go into court. They say, here are the forms, but you may be on your own. Sorry, Deborah, I think you were saying something. I cut you off. I apologize.
Oh, sorry. I said there are some forms for a complaint on the Pennsylvania court's website so that you don't have to think you're starting from scratch when you draft a complaint.
Right. Now, and realize too, even at these self-helps, generally, I can't say in every single time, but most of these individuals that work there are not attorneys, or they may not be able to give you legal advice. They may just say, okay, you're filing for eviction. You need this form, take it to that door over there, but they can't tell you how much time to give it a notice to quit, how to serve someone. You may be recalling someone like my office or a pro bono attorney to assist you with that. Once you file an action or you file the complaint, you must serve the defendant. Depending on what kind of an action it is, depends on how it's done. But in landlord-tenant cases, it has to be done either by a sheriff or a constable or by personal service. You can't do it just in the mail. Other civil cases, what we call original service, I can track it through a certified mailing where I can see the signature, like a little green card on the back. But after that, it's just called standard service, and I can mail anything through the postal service at that point. But if I can't show as the plaintiff that I served the other side, then my case could be thrown out, or I could have to come back and start all over again. Once the hearing is scheduled, the parties need to show up. If the other side doesn't show up and proof of service can be shown, the court could enter judgment against them without any argument. If you're the plaintiff and you don't show, they're probably dismissing your case on the spot. But if you're the defendant and you're not there to give your side of it, the plaintiff still has to meet their burden, but it's a lot easier to meet it when no one's, countering it on the other side. As a defendant, you have the right to ask for a continuance, whether it's to give you time to get an attorney or to get some things in together. It's going to be usually a couple days, maybe a week or two. And it depends on the judge. Some judges think tenants are just stalling. Others say, okay, you gave the name of an attorney, you said you're calling MidPenn or Community Legal Services. I know they're busy. I'll work with you and I'll give you 10 days to come back. If you get it the first time, probably not going to get a second one absent an emergency. If you're the plaintiff, they're usually very weary about giving you a continuance because the other side's the one that's being prejudiced by everything. When you go to court as a landlord, you should absolutely bring the written lease. If it's oral, you obviously can't bring one. If your community, or excuse me, or your county requires the housing inspection license, bring it if you operate a multi-unit building. If you did not have a tenant waive a notice to quit, bring a copy of what you gave them. Just like we talked about earlier, the tenant giving copies of things in writing, landlord should also have a copy of what was posted in writing. If you're asking for unpaid utility bills, that's the tenant's responsibility. Bring those bills with you or ask for a ledger from the utility company. Bring pictures to show the damages, proof of any payments, invoices, estimates as to the damages that were done. And if there's any contact in written communication between the parties, giving them notice about the damage, bring that with you. The worst thing you can do is say, oh, I shouldn't bring it with me. Bring it with you. If you don't need to use it, it's not going to be used. If you don't have it with you, it could end up in your case being dismissed. So when in doubt, bring it with you. For the tenant, if you're suing for the security deposit, bring the lease because it's going to say in there how much the security deposit was. Show documentation or bring documentation when the keys were returned and a forwarding address was provided. And you must give your landlord a forwarding address in order for the 30-day rule to get double the security deposit to apply. The 30 days start when possession of the unit is given back to the landlord. And a lot of times it's when did you give the keys to the landlord? Because ideally then you can't get back in. But if your landlord was there, there was no key, where it's like a digital key and the landlord says, okay, you're gone, and they wave you goodbye, your 30 days started then. And if you asked for the return of secure deposit, you don't actually have to technically ask for it, but if you did make it, any documentation saying, where's my security deposit? If it's on day 31 and you say, where's my security deposit? And the landlord says nothing, you ask, that's all you have to bring with you. In a court, so there are specific people who have the different power in the room. So the judge, they're the judge. I have different thoughts about non-attorney judge magistrates and lawyer magistrates, but at the end of the day, if they don the black robes, it's their courtroom, they're in charge, but they still have ethical rules they have to follow. The court staff is going to be there. They're going to tell you where you go. They're going to make sure etiquette rules like taking off your hat, not recording it. You cannot on your phone record it usually, but in a magistrate hearing, you have the right to bring a recorder and record the audio. Most counties will permit that. Again, maybe Philly doesn't. But okay, so they do not. But you have the right to use that as your official record because there's no stenographer or court reporter at the magistrate. But you have to tell everyone and get the judge to say that's okay to have the record. Lawyers were there to enforce the rules or enforce what's best for our clients. The parties can represent themselves. You may hear the term pro se. It's Latin for on your own. And the system was created not to need attorneys. We just kind of got good at what we do, and that's why people call for us. The court could have a security officer, it could be a constable, it could be a sheriff, depending on where you are. And they're enforcement. They could remove you if you're being unruly, if you're not following the rules, if you're constantly interrupting the judge. At the end of the day, a courtroom is a public area. Anybody can come into a hearing. Very few cases that they're sealed. If it has to do with like children or minors, then the judge can seal the courtroom. But any other time, if you are really bored, you could go to a magistrate judge, sit there and watch all the hearings. If you have the time to do it, go for it. But security is going to enforce the rules strongly there.
And the one thing I do also want to emphasize is that everybody should be treating everybody with respect, right? There should not be voices raised. There should not be fights. There should not be cursing. And that's from all sides. If there is a judge that is losing his or her temper or not treating somebody with respect and dignity, that's something that must be reported. So, everybody in the courtroom is supposed to be treating, I know on TV sometimes we see a lot of screaming, but you really should be treated with respect. You should be able to speak. You shouldn't be interrupted. So it's really important for you to know that.
And please understand too, attorneys, judges, we answer to the state Supreme Court. So if we do something improper, I have been yelled at by judges before. I have reported judges saying that they are wholly, unethical, but we all answer to a higher authority at the end of the day. But the idea is we're going to show courtesy, whether or not someone's represented or not. No attorney should be snotty or snobby. We don't want to give each other a bad name. So after a case is started, so in this case, a landlord matter, if either side is dissatisfied with the court's decision, you have a right to appeal the decision to the Court of Common Pleas. Now, each county is a little bit different. I know in here we have Philly, but here, everywhere you file what's called a notice of appeal. Now, in Philadelphia, you file with the Department of Court Records or the Civil Family Law Division. Other counties, it's just going to be with the prothonotary or the clerk of court of your community. It just depends on how your county is set up. In central Pennsylvania, where I'm located, and I know a few of you here are in Cumberland County, it's the prothonotary's office who's in charge. If you are appealing possession, meaning landlord's trying to evict you, the judge says, yeah, I find grounds for you to be able to have to leave. If you want to stay in the property, you must file an appeal within 10 days of the date of that judgment. If you're saying, I'll leave, but you don't agree with the monetary side, so how much money do you owe? You have 30 days to appeal the decision. If you appeal it, you must serve the appeal on the other party. And with it, depending on the court, there's probably what's called a tenant's affidavit that says whether or not you qualify for a reduced rate under what's called in forma pauperis, or don't make me pay 100% on the spot. If you are paying on a possession, you are paying what's called a supersedious. You have to pay your rent every 30 days into court. It's actually either your monthly rent or 3 times the judgment, whichever is less. If you walk out with a judgment of $0, you actually don't have to pay any rent to the court, but you can still appeal it when you do the first initial filing. If you have IFP status, you only have to pay 1/3 of your monthly rent at the time you appeal. But then you have 20 days to pay the remaining 2/3 of your rent. The problem with that is that from the day you started your case, when you put the 1/3, your 30 days from there started when your next monthly rent is owed, and it's the full rent. You don't get to do the 1/3, 2/3 anymore. It's solely the initial filing for the supersedious. And as long as that supersedious is in effect, and as long as you pay for it every 30 days, and you're paying the court, you're not paying the landlord anymore. So if you appeal on the 10th, every 30 days, please be careful. Okay, good, that was the next slide. Every 30 days, you're paying for the next supersedious. If you are late by even 1 day, the court or the landlord can have the supersedious dismissed, and then they can order what's called an order of possession. When a constable is coming out and saying you have 10 days, and if you don't leave in 10 days on this date, so that usually the 11th day, the constable will say, on this day I'm coming out, and if you are still there, they can forcibly remove you from the property, and they can take you out because ideally then legally you're not there. But as long as you have the supersedious, the order for possession cannot be granted at that time because the magistrate is told the case is paused while the higher court works it out. Now, just real quick with the supersedious, make sure you serve the other side. The landlord does have to file a complaint against you, a new complaint in the Court of Common Pleas. And now you're then in civil litigation where there is a time to answer it or file preliminary objections. If you get to that point, I encourage you to talk to an attorney because it's very specific and there are very specific rules, more rules at common pleas than the magistrate. Last thing I just want to briefly touch on is the current moratorium. So obviously we're still dealing with COVID. I think we're in a 4th wave, or I don't know if they're calling this one the wave. So right now there is a federal moratorium that is currently going through June 30th of 2021. This one is through the Center for Disease Control. Last year, Governor Wolf had issued one, and then that expired in September. Then President Trump had his CDC director issue one that then expired in January. And now President Biden's director has now extended it. It's already been extended once, now to June 30th. If June 30, is there 31 days in June? No, July 1, if there is no extension of the moratorium, then on July 1, the landlords have the right to seek possession of their properties. Now, the moratorium is only if the issue is the non-payment of rent. If it's a breach of the lease, the moratorium does not apply at that point. But if someone is saying, I cannot afford to pay my rent, and there are very specific rules. You've tried to get government assistance, whether it's through rental or utility assistance, which there is hundreds of millions of dollars in the state right now to help renters get their monies paid. And before, where they capped it at $750 and you had to waive the rest as a landlord, that's gone. Now you can get full forgiveness and your rent paid, your utilities paid through your counties. The counties are running it, but the state has the money. So please go and find that money. But if you earn less than $99,000 a year as a single person, you're unable to pay your rent or any substantial. You've made best efforts to pay even partially some of your payment or the full payment. And if you became evicted, you would either go to a homeless shelter or move in with somebody and you could give them COVID, then the moratorium applies to you. But if they're claiming it's non-payment plus the breach, the moratorium does not apply. You're not protected. The moratorium does not stop the landlord from filing the action. They can still get to the magistrate. They can still get the eviction there, but it cannot be acted. So the order for possession cannot be granted at that point. As a tenant's attorney, I'm generally asking for the hearing to be continued until after the moratorium ends. But right now, depending on the court, some may say, I'm not having the hearing at all. Others may have a status conference to say, where are we? Where are things at this moment? Others may say, okay, we had the hearing. I find that they've not paid their rent. I'm granting the eviction, but you can't act on the eviction until the moratorium ends. So again, right now it's June 30th. After President Biden's annual address, I know it wasn't a State of the Union, we believe he's going to push it beyond afterwards, beyond June 30th. But again, there is this rental and utility assistance, which we fully expect is going to continue, whether it's through the government or through the states at that point. And if you believe your landlord is not following the rules or they're taking action the moratorium prohibits, the state attorney general through the Consumer Financial Protection Bureau and through federally, through the Federal Trade Commission, they are monitoring and they are filing actions against landlords. But if you file the moratorium and the landlord tries to backdoor come after you and say you have to pay me for this, you can actually file with the Attorney General's office. I will just lastly note that if you can't pay your rent and it is not because of loss of income, you just don't want to pay it, the loss of income does not have to be related to COVID. It doesn't have to be I was laid off from COVID. It's just that I've had a substantial loss of income. If you sign the moratorium and say, I can't afford it, but you really can, it's a federal crime and you can actually be sentenced up to 10 years in prison for it. So I really encourage you, don't read it. If you're not sure if you apply, if you qualify or not, talk to an attorney like me or legal aid or any other attorney who does tenant work, and they'll guide you through that at that point.
Well, there is a question,
Sure.
but it says if a tenant is unable to pay rent due to coronavirus or losing employment due to pandemic, so that is something that you can fill out an affidavit for, but their lease ends, can they still be evicted as the lease is ending?
Yeah, great question. And I was hoping to kind of dance around that issue, but
Sorry.
technically, yeah, I knew it was going to come up. Technically, yes, the government has not said that the lease term ending is protected. No need to apologize. The lease term protects the, let me rephrase that. The government has said that no, that was not their intention to stop the non-renewal of a lease term. So technically, if a tenant cannot pay for rent and they're month to month and the landlord says I'm not renewing your lease and you owe me money, the non-renewal knocks out the moratorium. Now, if the landlord says it's a breach of the lease and the non-payment of rent, you go to court and the judge says there's no breach of the lease, the only thing left is the non-payment of rent, then the moratorium applies again. But yeah, if it's the end of the lease term, or if you have the moratorium, let's say you've had it for 6 months, it's only been there, but now your lease has ended, your landlord can go through with it now because it's the non-renewal of their lease. The case is being litigated in the federal courts right now. It depends where we are. Our Third Circuit has not seen it yet, but there are different courts out there who have said absolutely not. It doesn't apply. But short answer, no. If your lease ends, unfortunately, the moratorium does not apply, and the landlord could get possession without the moratorium at that point.
But again, eviction is a process that needs to go through court.
Yes.
So they shouldn't be locking you out without following the proper procedure.
Yeah, and if you're locked out, your utilities are shut off, you lose a front door, anything that seems like your landlord is trying to kick you out of there, call an attorney, call a group that does this, or whether it's like a neighborhood mediation service, but call for help. And if we cannot, we will generally refer you to somebody who can, or we'll try to put you in the right direction. But yeah, if you are a landlord, don't do it yourself. If you're a tenant, make sure you know that you are protected by the law.
All right, well, I want to thank Paul so very much. This was terrific. Thank you all for attending. Chelsea, thank you, and the Coy Library System for organizing this series. And again, if anybody has any questions, please don't hesitate to reach out to PMC or MidPenn. Thank you all.
Thanks everyone for coming.
Thank you. Have a good night.
Have a good night.